Walk us through this. Walk us through what we learned. Walk us through the warrant and the inventory and what you, on the basis of everything you know, take away from it.
Yeah. So to me, John, the big headline is the former president of the United States is under investigation by the FBI for a violation of the Espionage Act, among other things. So that to me is a headline. And then it's supported by two different things, the warrant and the inventory of what was found at Mar-a-Lago. And I'm going to start with the latter because, yesterday when there were all these reports of FBI going and trying to find nuclear information or signals intelligence information, I said, look, we got to be cautious because that's just what the FBI is looking for. We don't know what they actually found. Today, we learned what they found. And we learned that at Mar-a-Lago was some of the nation's most serious sensitive information, what is called top secret, sensitive compartmented information. That was at Mar-a-Lago. So it ain't no hoax. It's there. And there's no reasonable argument that could be advanced for why that material is at Mar-a-Lago. Donald Trump's not the president anymore. He has no need for that information. So that is a damning fact. We then have the second document, which is the warrant. That's what the FBI went to the federal judge with and said, here's what we need. The judge then signed off and said, here's what you are allowed to do. Now, in the warrant, which the federal magistrate judge signed, so he said that there has to be probable cause to believe that there are documents at Mar-a-Lago that are relevant to three specific crimes. One is 18 U.S.C. 793, which is called the Espionage Act, which is taking defense information against the interests of the United States or grossly negligently removing it from its proper place of custody, aka the White House. Also, it covers the failure to return classified or sensitive information when demanded by the United States. That is a 10-year sentence. Second crime is 18 U.S.C. 2071, which is concealment, removal, or mutilation of defense information. That's a 3-year penalty, but it also bars you from running for future federal office. And then the third crime enumerated that the magistrate judge signed off on is 18 U.S.C. 1519, which is a surprise to us. This is a statute about the destruction or alteration or falsification of records in an active federal investigation. So that's like, maybe Trump was flushing documents down the toilet once he learned the government was looking for them. Who knows? That's the one that probably does require an inside source, a mole or something like that, working with the FBI. Otherwise, it's hard for me to understand how the FBI would have thought that would have been a potential crime. So those are the three, and it's looking incredibly badly for Donald Trump at this point.
So, Neil, I just stick with you for one question here. There's obviously going to be a ton of focus. I'm going to ask Ben about it in a second, and Phil about the classifications, what top secret means, what these various things mean, and the Espionage Act is the thing that's obviously the eye-catching thing here, and maybe the most consequential thing, probably the most consequential thing for our politics and for Donald Trump's legal liability. But am I not right in thinking that the lesser statutes, the basic ones about like how you're not supposed to take classified material out of the White House, that the fact that they have discovered documents, if what's in those documents, what's claimed in the inventory is things that are top secret, things that are secret, and things that are confidential, that those are all that on a prima facie basis, we already know. I mean, I shouldn't say we already know. We can conclude that if those things are properly marked, that Donald Trump's violated the most basic of those three federal laws already.
You're absolutely right, John, but you don't even have to go there. So these three crimes that are isolated in the warrant don't actually require classification. They just require defense information. And there are two sections of the Espionage Act, 793 D and F, which cover people who actually did have the authority to have these documents, and it bars them from mishandling that, even if they had the authority at one point. There's so many problems with this whole president, automatically declassified the documents. I don't know where to begin. I mean, one is he didn't go through the proper procedures for doing so, and the Court of Appeals has said even presidents are bound by those procedures. And another is if it's nuclear information, the president actually doesn't have the ability by law to declassify it. But I think here the Justice Department was pretty careful in on isolating these three statutes, which don't even require classification at all. So it's an argument that I suspect we'll hear a lot about. But should this go to a federal criminal trial? And honestly, my view right now is it is going to go to a federal criminal trial. I don't know how you could look the other way on something of this magnitude, but we'll let the facts play out. But if it does go to criminal trial, I don't think these classification defenses that Trump is trying to put out on social media are going anywhere.
And can you just remind me, I know you just said a second ago, what's the potential penalty for that? How many years in jail? Just on that one charge?
So each of the three crimes has a different one. For the Espionage Act, it's a 10-year sentence for each violation of the act. So these are big sanctions. The other ones are 3 years and 20 years, depending on the statute.